Welcome to the Madrona Group's 15-minute forms, where we choose a form to talk about for about 15 minutes in hopes to develop a better understanding of it and how to use it in our transactions. Today, I wanted to talk about occupancy agreements, specifically the pre-close and post-close occupancy forms 65A and 65B. Well, when would you use a pre or post occupancy form? If we think about what our purchase and sale agreement says, it gives the buyer the right to own the property at a specific date from our contract. That closing date is what they call the date of performance. So, what happens when one party either wants to move in early or wants to stay in the property later than that closing date, and that the new owner doesn't have complete and full use of their own property? We reach for forms 65A and 65B. The first thing I wanted to point out is on your purchase and sale agreement, when you mark box 11, I guess it's not a box, when you mark line 11, you're going to mark the closing date. The closing date is the date of performance, where this contract ends and all parties must perform as they should within the transaction. This means the sale has closed and the deed has transferred to the other owner. Now, when you look at possession date, I'm going to get a little closer here. When you look at possession date, that date is also an option on our contracts. We can either have the possession date be on the closing date, or we can have something that says other. If you have a seller who needs to stay for a few extra days and everybody agrees to do so, then the possession date for that buyer is going to be the date that the buyer has complete and full access of the property and its use. If you have a buyer who wants to potentially move into a vacant property before the closing date, then that buyer does have possession and use on that date that they move in. So this is the date that the people transfer. The closing date is the date that the deed transfers. In our purchase and sale agreement, we do have a very distinct definition of what closing and possession actually mean. So within our 6 pages of boilerplate language, paragraph F does define what closing is and what possession is. Now, if nothing is marked in your closing and possession, you do need to have a selected box. There's not a default for this box, and not selecting that box could get you in a little bit of trouble figuring out when the transfer of people will happen versus the transfer of legal ownership. So refer to paragraph F in your purchase and sale agreement to give you a good definition of what that means. It says here that closing is the date that all documents are recorded with the sale and are available to the seller. At that time, the seller does need to deliver keys to the buyer, and all of this shall happen, and the buyer shall be entitled to possession of the property at 9 p.m. So unless you want a different possession time than 9 p.m., it's advisable that you do mark a specific time or a specific action to take place. Now, keep in mind, too, it also says, if possession transfers at any time other than closing, the parties shall execute either a 65A or 65B. This is line 85 that I'm looking at right now. This, again, is in our purchase and sale agreement boilerplate language, and it's in all purchase and sale agreements. Now, when you have occupancy that happens other than on the possession that happens other than on the closing date, we do need to make sure that we are advising our clients of the risks of this. We are not necessarily going to be entering into a landlord-tenant situation, but this is definitely an owner-renter situation. So I wanted to pull up first 65B. This is probably the most common of those two scenarios that we're going to come across. 65B is the rental agreement for the seller to stay in the property after the closing date. Now, because this is a rental agreement, we do want to treat it as a rental agreement. There are some creative ways we can do this. If it's just a few days and you've decided that your seller can stay in the property for, say, a week, and the buyer gets to move in after the seller has had a chance to move all their belongings out, and the buyer decides, I don't necessarily want to charge rent for this, so how would I do this? You do have the option and flexibility of putting $0 in for that first week that they said they've stayed, but You do also have the option of charging a specific rent amount after that if the stay goes over the agreed date. Now, I always recommend putting in some sort of dollar amount because what good is a rental agreement if you're not collecting rent? Now, you can't go above and beyond what a normal rent would be, but again, it is very flexible. So if they want it to be essentially free, you can have it be $1 for the first week, and then you can have it be, $2,500 a month starting the week after that. So that is one of the ways that we can protect our buyers and sellers with having an end date and having a consequence if that end date doesn't get met. No rent at any time can be collected more than 3 months after closing. And the reason is this occupancy agreement is not part of the Landlord-Tenant Act. It is not protecting any of these people against those rules. This is a separate in itself agreement. Once you go past 90 days, you enter into those protections of landlord-tenant law, and then you have to go through the due process of eviction if necessary. So if a rental agreement is in place and it is in place for 3 months, you may collect 3 months worth of rent. But if that stay over is longer than 3 months and that other tenant at the time is going to turn into a tenant decides to keep paying and the owner keeps accepting, then they have entered into an unwritten, unspoken, but very much implied landlord-tenant relationship. Do not let your client accept any payment after 3 months in order to be protected with this versus the Landlord-Tenant Act. Now, this form is generally pretty simple. You go ahead and you write where the rent is going to go, how much it's going to cost. Now, your buyer is going to be the owner. The seller is going to be the renter in this scenario. So make sure that you do line those up correctly with the people that are staying. If you have 2 sellers, but one of them is going to stay, then only that one seller needs to be on this agreement. This agreement is separate from the purchase and sale, but connected to the purchase and sale. So if you do have a possession date that's different, it has to be included within this purchase and sale agreement, but it is on its own contract. You'll have a termination date. That termination date is going to end the same date or same time that all of our other forms end, which is 9 p.m. Make sure you do write your termination date because all contracts must have a date of performance. Then it is required that the property still remain insured. If the seller is holding over and they become the renter, then they are responsible for having renter's insurance for when that date of possession happens. Think of it like this. They own the house till the date of closing. On the date of closing, they become a renter in someone else's house. They have to do all the things renters would do, and the buyer who bought this property is going to also have to insure it as if it is their own home because it is as the date of closing. Now, utilities, the renter is going to be responsible for the utilities after that closing date and not able to make any alterations to the property as if they are a renter. So all the things do apply as renters do. Once that closing date happens, it is no longer that person's property. On page 2, we want to make sure that we're also checking the boxes that the property has smoke alarms and smoke detectors, carbon monoxide detectors. It is required to have these things in place if you are selling a residential home. If the home is vacant, you have to have a bare minimum amount of smoke alarms and carbon monoxide alarms. But if you become a landlord with a seller that stays past closing, you need to make sure as the owner now that the home is truly equipped with all of these required things. You also need to make sure that you are giving the renter a copy of the mold disclosure. This just says that in the state of Washington, we have a more moist environment and it's possible that mold could develop. It's just one of those pamphlets that everybody is required to get once they become a renter or a buyer. Now, if a buyer wants to move in before the closing date, then the buyer can start renting the property before that with a Form 65A. It's filled out the same way as 65B. You put in the buyer, who is going to be the renter before closing, and the seller, who is going to be the owner. You'll identify the property address, and then you're going to do a rent. Now, it's possible that this rent might be a per day rent. It might be a per week rent. I don't know. It depends on the situation that you have at hand. But keep in mind that if closing is delayed, then this rental agreement here is going to dictate exactly how much rent is going to be paid to the current owner. One thing to keep in mind is when you do something as a rental like this in this situation, rent is prorated. So if you put here that the buyer can move in a month early and closing ends up happening 2 weeks early instead, because you're able to move it up, then any rent that was paid for that month will be refunded and prorated as they would, because rent is prorated, deposits are not. Again, you're going to want to write a rental amount. You're going to want to write the frequency of that amount. So the rent shall be so many dollars per what? Per day, per week, per month, payable to who and where. You'll also want to make sure that you do have a termination on this, which in this scenario with an early occupancy, the termination should match the closing date of the purchase and sale agreement. As the other one, the insurance does need to be kept on the house. The owner needs to keep the normal policies that they would. The renter is going to have rental coverage against renter's insurance, so their own personal belongings. And the owner is going to have no responsibility in insuring anything that belongs to the renter themselves. The renter is going to be paying the utilities during this time. So again, we will prorate all of those things, and this goes through escrow at closing. The renter is not allowed to make any improvements to the property because they are renting the home they do not own yet. One thing to keep in mind is this one does have an unlawful detainer, which is paragraph number 6, that says it is subject to the unlawful detainer statute. And if the renter and the owner have entered into a purchase and sale agreement for the property, then a default under the purchase and sale agreement does count as a default for this agreement as well. And that ends this pre-rental agreement. So a buyer is not allowed to rent a property before closing and then never close on that property just to be able to rent that home. Like the other agreement, this one does have information for smoke alarms, smoke detectors. It does have a release from us because we as agents are no longer responsible for how the relationship between these two parties work. We are not facilitators of this in any way whatsoever. And anytime you have a client who's considering letting a seller hold over or letting a buyer move in early, they should be advised to speak to an attorney or somebody who is an expert in this in landlord-tenant law, because we are not going to be able to advise them on how to do that. There are risks involved in all of these scenarios. You will always have the possibility that one party may not perform the way they were supposed to per contract. So anytime you have somebody talking about pre or post occupancy, make sure that you're reaching out to somebody like your managing broker or your designated broker to discuss all of those scenarios and how to face that with your clients. If you have any questions about pre-close or post-close occupancy, I'm here to answer them for you.